Okay, I'm good.
We're hoping that it's going to work fine. As it talks in here today.
Okay, I was here. We went to that one session. There was one, but there was two other ones.
Maybe not. Yeah, I don't know. Well, I think, yeah, it is. It's water and light.
Welcome to the Impact of Children's Participation in their Review Hearings. My name is Haley and I have been a member of the Nebraska Foster Youth Council for about a year. A pilot study involving 93 children in Lancaster County compared children who attended their hearings to children who did not regarding potential risks and benefits of participation. This session will report the findings of the study regarding impacts of participation on children and on the court process. Our session will be led by Vicky, Weisz, and Sarah Beal. Let us first welcome Vicky, Weisz. Vicky Weisz is a research professor of psychology at the University of Nebraska-Lincoln Center on Children, Families, and the Law. Vicky received her PhD in clinical psychology from Washington University in St. Louis and her master's in legal studies from the University of Nebraska College of Law. She is a director of the Nebraska Court Improvement Project, a federally funded program focused on improving the state judicial and legal system for abused and neglected children, and serves as the main staff support for the Nebraska Supreme Court Commission on Children in the Courts. She also serves as part-time staff on the Midwest Child Welfare Implementation Center. Her research projects include assessments of court legal process, evaluations of innovative legal or KC legal programs, and children's participation in court. Welcome, Ms. Weisz. And we have Sarah Beal. She is a doctoral student in developmental psychology program at the University of Nebraska-Lincoln. She is primarily interested in the role of children and adolescents play in facilitating their own development, as well as their interactions with their environments. For the past year, Sarah has participated in research on children in the court process and the effects of case progression at the University of Nebraska-Lincoln Center on Children, Families, and the Law. Andrea Corey will be moderating our session today. For those of you who didn't meet her in her earlier session, she is the director of the ABA Youth at Risk Bar Youth Empowerment Project, focusing on adolescents' access to attorneys, children's right to counsel, and youth involvement in court hearings. She's also an assistant director of child welfare for the National Child Welfare Resource Center on legal and judicial issues. She received her JD from the University of Baltimore School of Law in 1997 and her BA from the University of Delaware in 1994. All right, I will now turn over things to Ms. Corey.
And actually, Ms. Corey is not here, so we'll turn it over to me.
Thank you.
Thank you. Thank you very much. Welcome, everyone. And what we're going to do is I am going to just sort of set the stage for this research project discussion, and then we're going to turn it over to Sarah to give the results. And I would like to introduce Sammy Mosher, who's sitting right behind Judge O'Neill. And Sammy was one of our crack research assistants, and some of the judges might recognize her from sitting in the back of courtrooms. But she was one of the people who helped gather the data for this study. So what I'd like to do is just talk a little bit about the other, this one. Thank you. Just want to talk a little bit about the history of children coming to court. The first thing, I just want to sort of lay briefly the international and national picture about this. The UN Convention on the Rights of the Child, which the United States and Somalia are the only two nations that have not signed. But it was signed by states all around, countries all around the world. And that included in it, and I want to read this. It established the right of capable children to directly express their views and to be provided the opportunity to be heard in judicial and administrative proceedings, either directly or indirectly. And that actually was written, and the process of getting it approved by various countries started in the late 1980s. Partly related to that, or spurred by that, in 1989, England and Wales passed the Children's Act of 1989 that implemented a requirement that courts and local authorities elicit the perspectives of children in care and consider those perspectives in their decision making. So there's been a history around the world of increasing involvement of children and youth in their foster care proceedings. The United States kind of has come to this a little more lately, but the Pew Commission, which did a large study in the early part of this century and made some recommendations that actually have been quite instrumental in some of the federal law that has been passed. They recommended that courts be organized to enable children and parents to participate meaningfully in their court proceedings. And some of you have been to the Andrea Corey sessions. The ABA, the Center on Children and Law, has really led the national efforts in promoting children's participation. And actually, as of 2009, according to a survey conducted by the ABA, 2/3 of the states in the United States have statutes that make children a party to their proceedings, and also give at least some children, sometimes it's older children, in Nebraska it's 14 and above, and in other states it would be similar, a right of notice and participation in the hearings. And then finally, there's been recent federal legislation, and that is law that's tacked on to the ASPA law, but it's Public Reconciliation Bill, something, I don't remember it all, but amended the Social Security Act that covers child abuse, that sets forth a requirement, and again I want to read this, that the court or administrative body conducting permanency hearings consults in an age-appropriate manner with the child regarding the proposed permanency or transition plan for the child. And I think Howard Davidson mentioned that yesterday. So there is the federal regs kind of watered that down. So judges don't actually, according to the federal regulations, have to talk to children, but they are required, there is a requirement that they get the child's perspective. But anyway, so this is just to give you a background of children coming to court, and I'm going to see if I can do this, Sarah, because otherwise, when we switch, okay, well then I'll do it for you. Okay, so what are the concerns about children coming to court? And I know some of you in this room may have some of those concerns, but certainly some of the reasons that people don't want kids to come to court. And I will say, a year and a half ago when we did guardian ad litem training around the state, this issue, because the Supreme Court guidelines recommend that guardians ad litem facilitate children's participation in their court hearings, that issue was the one hot issue every time. I mean, it could be completely dead crowd. And then when this was discussed, there was volatility on both sides. I mean, not just against, but also for. And the two reasons are, I mean, the main reason is that people are concerned that it's too stressful and painful and don't want to re-traumatize children by the court process. Children who've gone through so much. And there is, I think, coming from a good place, a desire to protect children from things that might be harmful to them. And some people have argued, as I have myself, although I have been a proponent of this, with the questions not completely settled, even though these articulate, and I do want to welcome our articulate youth, some who were in the video and who've been here through the conference, sharing their opinions in different meetings. Some people have argued or have at least questioned whether they represent your average kid in foster care, because they're so articulate and so assertive and, you know, are wanting to promote their, you know, it's kind of like they're the student council leaders of foster kids, and do they, what they want, does that represent what, you know, everyone in foster care thinks? So that's sort of has been an unanswered question. The other thing people have been a little worried about is whether kids coming to court would disrupt the court process, where important decisions have to be made, fundamental fairness for parents, all of that, and you know, does it do something that affects the process? We've really not had a lot of empirical evidence to date. There have been a few studies, and I want to just mention them briefly. There were some studies of children testifying in sex abuse proceedings, and they were in the early 90s. Gail Goodwin and some of her colleagues did this, and they basically got kids who testified, and these are, you know, testifying against their assailant, alleged assailant, and much different, I mean, a much more difficult kind of thing, and they had a control group of kids who didn't testify, and those were cases where, you know, they didn't go to trial, basically. And what they found, and then 15 years later, they followed up and got like 80% of the kids who had been in that original study. I think it was 80%, a pretty high percentage. So what they were looking at, in the first study they looked at initially, was it traumatic for kids to testify? And they found that there was short-term stress that was pretty significant for some kids. So it clearly was upsetting for kids to testify against their assailant. But interestingly, that really subsided over the months that followed. And then when they looked at these people 15 years later, it had no negative effects at all. I mean, there was nothing negative about it. But the kids who did testify viewed the court system as more fair than the kids who did not testify. So 15 years later, there was this positive trust and confidence in the courts that the kids who did appear in court had. So there have been a lot of little studies that have not been controlled, but all around in Britain and Wales and even in the United States. And pretty much whenever you get a group of foster kids and survey them, they want to go to court because they are affected by what happens and they want to know what's going on. And older children particularly would like to say what they think. But you know, the studies have not been on point to children in the foster care system exactly. So I think now, well, we'll just go to the next slide. Great, thank you. So this is what we wanted to do. We wanted to answer these questions. Is attending court harmful for children? I'll speak up and raise your hand. Judge I, you tell me if you can't hear.
I'll turn my hearing aids up.
Okay. Is attending court helpful to children? Is the age of the child related to these other findings? So, you know, we want to see, does it make a difference? Does what the judge does have an impact on any of those things? And then finally, what's the impact on the court hearing itself when children come? And I will now turn this over to Sarah, who will describe the study. This is Sarah Beal.
I'm going to briefly go over the participants and methods. You have those slides on your flash drive so that we can spend more time talking about the results. So we had 93 children between the ages of 8 and 18 that were in Lancaster County. All children were at review hearings for abuse and neglect cases, or were participating. 55% were boys, 57% were white. Cases had been open between 4 and 194 months and received consent from the children, the caseworker, the GAL, and when appropriate, the parent themselves. And then of those 93 children, 43 attended their court hearing. So the measures that we used when children attended, I tested this earlier and it was working, but it has failed us. When children attended their hearing, we administered a brief survey before the hearing and then again after the hearing. We also observed the hearing itself and then coded for different aspects of the hearing. And then 10 days after the hearing, we did a follow-up interview at the child's placement. And for children who attended their hearing, we asked 37 questions. For most of those questions, there were response options that ranged from 1, which was strongly disagree, to 5, was strongly agree. There were also some open-ended questions asked at that time. For children who did not attend their hearing, we still observed the hearing itself and then did another follow-up interview 10 days later. And in that questionnaire, there were 29 items. There were some items we asked the children that attended court that were not relevant for children who had not attended. For both groups, we compared child reports to our own observations in the court hearing to code for things like accuracy.
Children were invited to participate if they had a review hearing between February of 2008 and March of 2009 and were placed within a 1-hour driving distance. And then researchers reviewed the case files for placement information and case history and those sorts of things, so we took those into account as well. So question number 1, is attending court harmful for children? So immediately before and after the hearing for children who had attended, children reported that they were not nervous, so that's a comparison of before and after. So slightly more relaxed after the hearing, but again, not a strong affect. Children felt relatively happy both before and after the hearing, and then after the hearing, children reported that they felt the hearing was good. So these are averages. We also had responses and open-ended questions that children could give us before and after, and we're going to include some of these quotes throughout the study so we can hear those as well. So these are the kinds of responses that children said when we asked them about what they thought about their court hearing. One of them was, court is interesting, it's different from TV. There were a few occasions when children were extremely emotional in the hearing. Overall, children were relatively calm and quiet, but there was one case where the girl was extremely emotional, very upset during the hearing, was crying so hard she could hardly stop to talk. And after the hearing, she said, I didn't like the decision the judge made, but it was probably the best decision. So children are really dealing with trying to reconcile, sometimes wanting to go home and recognizing that that may not be the best thing for them. But I think it's important to note that those kinds of emotions, first of all, occur in lots of different situations, not just in the courtroom. So they're probably experiencing those emotions in their home placement, at school, at lots of other places. And then from a developmental perspective, adolescents especially are grappling with becoming an adult and recognizing that sometimes what we personally want is not necessarily what's good for us. So being able to go through that process and work through that in the court system and in other places is really good for helping with development. So even when children are emotionally aroused, the experience is typically fleeting. It may only last a few minutes, and while it's uncomfortable, those things pass relatively quickly. So at the follow-up interview, children who had attended court said that they tended to disagree with the statement. It was hard to talk to the judge in front of everyone, so they felt relatively comfortable with that, and did not feel upset while they were in the courtroom. So this is them reflecting on that they may have had some emotions while they were there, but overall it was not traumatic enough for them to feel like they shouldn't be there. And then children really want to talk to the judge when they're in that courtroom. That's something that they're very focused on. So one girl said, I didn't say anything in the hearing and it kind of made me mad. My CASA said that she would say something about my wishes at the next hearing. So children are really grappling with those kinds of issues. And they see the value of attending court even if they themselves are not going. So at the follow-up interview, all children, regardless of whether or not they attended their hearing, said they did not think that court was or would be too boring. So they're not feeling like this is going to be a horrible experience for them to go through. And then was or would not be nervous about going to court. So they're not having extreme anxiety about thinking about going to the court process. To be clear, court is not always the most enjoyable experience for children.
But there are a lot of things that children have to do, including going to school and going to the doctor's office and those kinds of things that may not be the highlight of their week, right? One girl told us, court is stressful and boring and sad. I'm tired. Court is stressful. I want to go home. I miss my friends. Leaving foster homes is stressful. I'm worried about school. I can be myself here. My foster parents treat me like a normal kid and not like a foster kid. So children, and especially those who are older, are experiencing lots of complex emotions, both inside the courtroom and outside of the courtroom, and they're dealing with those issues. But attending court and being able to be there gives them the opportunity to feel like they're having an impact on that process, and so they're able to cope with the difficulties of foster care itself. So is attending court beneficial for children? Children who went to court were glad that they went to court and felt comfortable answering the judge's questions. And again, these response options range between agree and strongly agree. So you can see that there's a very high polarization towards this. I am very glad that I went to court. I'm very glad that I was comfortable, or felt very comfortable answering the judge's questions. Many children feel excited about the opportunity to go to court. There was one girl that I was observing in the waiting room before that she was expressing to her caseworker that she was so excited about being able to see the judge and talk to the judge. She got into the hearing and she said absolutely nothing. So there are lots of times when the judges may not be able to see that that child is enthusiastic about being there, but the child really is excited to be able to participate. And because children attend court, they learn about the process itself and how they can be involved and have an impact. So this 15-year-old girl said, other kids might think the court system is bad, but it's not really. You have to learn how to do it the court's way. I got to say my thoughts in the courtroom, and now it is helping. It keeps me on track. Otherwise, I might have been in jail. For children going to court for the first time, it's also important to keep in mind that they may be very intimidated because they don't know what to expect. So children who did not go to court and were thinking about the possibility of going to court said that they had mixed feelings about attending their court hearings. So they weren't quite as enthusiastic about it. They were having some convoluted emotions. And then they also had mixed feelings about talking to their judge. But they haven't had those experiences before. They may not have been prepared to go to court, and it's understandable that they would have some mixed emotions about that experience. When reflecting on her first time in court, one 16-year-old girl said, at first I didn't know how court worked. I was nervous. I had something to say, but I didn't say it because I was nervous with other people in the courtroom, not because of the judge. If it were just the judge, I wouldn't have been nervous. And there are some differences between children who attend court and children who do not attend court. When we compare children who attended court to those who did not, children who attended court were more likely to view the judge as more fair and as more trustworthy, to feel they had a better understanding of the case, to say they would ask their GAL questions if they didn't understand something, and to feel that their GAL and their caseworker were both doing a good job. So being able to attend that court hearing and be involved in that court process has a huge impact on children feeling like the court process itself is more fair and the people that they're involved with are doing a better job. And these findings resonate in the statements children made to us. One 17-year-old boy said, it's good to go, you know what's going on and decisions aren't made without you. So they value being involved. It's worth it to go to court if you hear things from others they might not be the truth. And this we heard lots of times from children, that they didn't necessarily trust what was going on when they weren't there because they hear lots of mixed feedback and things that don't necessarily agree with each other. A 12-year-old girl said they need to tell kids more about what's going on and the process overall. They use really long words we don't know. So children not only want to go to the hearing, they want to understand what's actually taking place and be able to have those findings translated into something that's developmentally appropriate for them and something that makes sense. So as professionals, it's our obligation to make sure that both before, during, and after the hearing, that they're understanding what's taking place and what's going on. So the next question was, is court beneficial for all children? What are the effects of age? So older children tend to attend their hearings more often, are more willing to talk to their GAL, and that's from self-report, say they understand more of the details of their case and understand more legal terminology, and are better at discerning what they understand and what they don't understand, which makes sense developmentally. And then they're more accurate with regard to the judge's decision, so they have a better accuracy in recalling what had taken place. Now it's important to keep in mind that when we talk about older versus younger children, children who participated in our study were between the ages of 8 and 18. So older children are ages 13 and up. Now there may be certain ages in which children might not benefit as much directly from being in the courtroom. So it might be helpful for the judge to see an infant or a toddler, for example, but that toddler is probably not receiving huge benefits from being there directly, as opposed to a 14 or a 15-year-old girl that has the opportunity to express her feelings. One girl said, children under 5 should not go to court, but older children should go. So children themselves recognize that there's probably some benefits for older children that younger children can't experience. But there were some benefits to age in our study, and again, we're talking about the difference between 8-year-olds and 13-year-olds that were surprising. So age was not related to how nervous or relaxed children thought they would be. They tended to feel like overall they were comfortable. Their difficulty talking to the judge in front of everyone, they themselves reported that they didn't feel more or less comfortable based on age. Feeling upset in the courtroom and thinking court would be boring were not related to age, so we didn't find any differences there. In fact, younger children are equally excited about going to court. One little boy who had not attended, but the judge had ordered that at his next hearing he had to be there, said, "I think kids should be able to go to court, and they can." So they're very excited about being able to go, even at a younger age. So what occurs while children are in the courtroom is also critical for how they're feeling about the court process itself. And the thing that children most focus on is their interactions with the judge. That's really the highlight of their experience. Based on 43 children who attended their hearing, where judges were asked to vary the types of interactions, the types of questions and things that they provided when they interacted with the children. For judge that provided encouragement, children reported feeling more comfortable about talking to their judge in front of others. Children felt less upset during the hearing, and children were more knowledgeable about the details of their case afterwards. Now this was initially something that sort of threw us off, but as we thought about it, when you're providing encouragement to that child, they're going to be more invested in what's going on because they recognize that you're invested in them. So they're going to pay more attention to what's going on, they're going to be involved and invested in that case, and from that they're going to gain more knowledge and understanding of what's occurring. And one child said, being in foster care is weird. Kids make fun of you, but the judge talked about how successful we are. So that was a huge impact on her, that she was able to cope with all of the negative things that she was experiencing when that judge said, you're doing a good job, you're being successful, you're going to make it. Unfortunately, judge interactions can be limited, and when that happens, children feel uninvolved and disengaged. One boy said, there's not much interaction or input when you go to court, you're not included. My judge never interacts with me. I feel like no one actually listens. So involving children and providing encouragement when they deserve it, and by asking questions, can really enhance the experience that they have when they're sitting in your courtrooms. When judges asked children questions, children reported feeling more comfortable in the courtroom, feeling less upset during their hearing, were more interested in going to court in the future, reported wanting to go to court more than doing other activities such as going to the park or going to school, and were more likely to believe that children should be able to go to court. So it's important to note that the judge interaction data were from our observations. So this was not a case where we asked the child if the judge had asked them questions. We ourselves had noted whether the judge asked questions of the child and found these differences. And judges should do their best to interact with children, but obviously there's going to be a wide range of responses, from nothing at all or just nodding heads to being extremely talkative. This 11-year-old boy said, the judge asked me if I understood, I lied. So there's only so much you can do, but it's important to try and make those investments. And as children get more comfortable and go to court more often, they're going to be more willing to open up and share things with you. So this 10-year-old girl said, I would like to go to court, sure, if I'm needed there. Children want to go to court, but they don't want to just sit there in the back of the courtroom. They want to be involved and feel like they're part of the process, and it's important that they're engaged in that they feel like they're actually participating as opposed to just sitting there. This little girl said, I didn't understand what happened in the court. There were a lot of big words. I sat at the table, but I was not a major part. They should simplify it for kids, but I think kids should come more. And my experience during the hearing was that a lot of times judges did not translate quite as well as they could have when they were in the hearing. I had a master's degree when I started this, so I'm more educated than most 13 or 14-year-old children. I had a hard time understanding it. It took me 3 or 4 times going before I understood what exactly was taking place. So I think it is important that someone take the time to make sure that they're explaining to children what's going on. And I know that a lot of you have busy dockets, you're full, you're not quite sure how you're going to cram in that extra 2 or 3 minutes talking to kids. So we wanted to make sure that children were not having a huge impact on the court process. And this was extremely interesting for us. So when children attended as compared when they did not, hearings were shorter by about 10 minutes. Children's current situation, visitation, and medical issues were less likely to be discussed when children were sitting in the courtroom. The attorney, parents, attorneys, and judge were less likely to elicit or to provide information during that hearing. Permanency was discussed in greater depth when children were there, which was good. And then it's important for me that I note to you that in general, children were paying attention and were not disruptive in the back of the courtroom. And again, these are all based on our own observations, yes.
Is the implication from that if the child is there, it makes the child feel better, but the hearing is less effective? I mean, the children's situation, visitation, and medical issues are less likely to be discussed?
Those are less likely to be discussed in the hearing when children are present, yes.
We actually, in the judges, there are 2 judges in the study that we discussed these, one judge in the study, we discussed these findings. And one of the things they wondered is whether workers were less likely to bring children when it was a more complicated hearing. And so that would be a limitation to the study if children were only going to the more routine. So it may just be that that's where the children went. Or it may be that when a child is in the courtroom, people don't want to talk about those things as much. And
are they more protective? Are the adults more protective of the child when the child is present?
So one or both.
And that's something that came up in Andrea's discussion as well, that several people had mentioned, that they were concerned with going into great detail when the child was sitting in the courtroom. So it may be a combination of children not coming to hearings that are where people know that it's gonna be a difficult issue to discuss. Did you have a question? Sorry.
Ask Mr. Broughton what his perception was.
I think that I'm a lawyer in Lancaster County. I think that we self-policed, and maybe it didn't happen in any of your hearings, where if we needed to talk about something and it was a good opportunity to talk about it, we just asked the kid to step into the hallway. And so the reality is, my perception's always been, whether it's right or wrong, that I can accomplish more outside of the courtroom than within the courtroom. And if we have a lengthy court hearing, that's because everything's not going the way it should be going. And so realistically, it's difficult for me to really gain much from the data. It's just hard to interpret whether these hearings are ones that nothing happens, the court report's offered, there's no objections, we comment on how everything's going well and we're hoping it's progressing, and the kids hear that. Most of our cases, the kids are shy about saying anything, and even when there's sibling units there, if the first sibling says nothing, then usually the rest of the siblings said nothing. And so I was one of the naysayers at first, and for me it's just transitioned into a process where we need to remember that it's about the kids, and I think that's the one forgotten piece in most of our cases. Ironically, it's difficult to comprehend how we can forget about the kids, but I think that routinely would happen. So to answer the question about whether or not we were shepherding the information differently with the kids there, obviously we would, but I think anybody who attended the conference in Nebraska City realized the kids have gone through a lot more traumatic things than sitting in a courtroom. And so it's probably not as harmful for them as what we anticipate.
If we could ask, I talked to some of our foster youth about, the highly emotional, stressful things that can happen in court, whether they're there or not. That the judge telling a mother, you're not participating in your drug treatment, and you've been using or whatever, and your kids are not going to be going home, or you may lose your children or whatever. And I asked them what they felt about being there. I mean, if they wanted to be in those kinds of hearings too. Do any of you want to comment? Maybe you can stand up so people can hear you. Would anyone be willing to comment about whether they would like to be there even if it's awful?
I know I speak for Mickey when I say this, and I'm not so sure about Lexi, but we do want to be there. No matter what's going on, if it's going to be more traumatic, I think we want to be there more than if it's just a review, because we're talking about like our parents or our situation, where we're going to go next, and we want to be there, we want to hear that. And if you're talking about our parents and how maybe their UA wasn't clean, and that's not something that your parent or your foster parents are going to tell you, we want to be there so we know that. It's like kind of like a reality check for us. I would guess, we want to generally protect our parents, but we do want to be there. We do want to see what's going on. We want to see the stuff, and we've already lived some things that are going to be naturally just worse than sitting in the courtroom, like you said. It's like, to us, I guess I would say, for me, it's not really like a big deal. I mean, as you guys would imagine, I suppose. I mean, I've seen some pretty bad things, like in my own home and courtroom. It's not that bad, at least for me. I don't know about Vicky or Lexi, but I know I speak for myself when I say that.
I'll go off the fact of that she said like the UAs. A lot of kids always believe their parents over anybody else, thinking, oh, the judge is lying. My mom's doing what she's doing. Like she's doing what they told her to do. And the mom will be like, oh, I'm doing everything. They're just keeping you away from me. They don't want you to live with mom. And a lot of parents do that. And the kid will sit here and say, oh, my lawyer's bad, my caseworker's bad, because they don't get to see it face to face, hearing the judge saying, you're not doing what you need to get your kids back in the home. So we believe our parents, whereas if we're there in that setting and we see that she's really not doing what she's saying, it's point blank right there, we know what's going on.
So do you think that's what has an impact on feeling like you trust the judge more and then trusting the process more and that sort of thing, because you hear firsthand?
I mean, I think it's one of the things that we discussed and they thought was a great idea was that if a judge knows you're about to do that, so the kids are there and you know that you're now getting to the mother's dirty UAs, that you could take, and everything takes 20 seconds, so even though you feel busy, ask the kids to approach the bench and say to them, I'm about to start talking about your mother's not doing well in drug treatment. Would you like to stay or would you like to leave for a few minutes? Because they thought that some kids might like to leave, but they still might like to know what it is that they're missing. Because sometimes kids are excused from the court, but they don't know why, and they don't know what's going on in there. So that they would kind of like to know what it's about generally. But some kids might have liked to leave. They said they would like to stay in those circumstances, and I don't know.
I was just thinking of the idea of even having the GAL kind of preface topic areas that they anticipate coming up, maybe because they've conferred with parents' attorneys, they know what the reports are going to say. Now we're likely to get into some things today about X, Y, and Z. Are you comfortable being there for that, or would you want to be excused for that part of the hearing and just doing a little preview before the hearing starts and finding out what the wishes are?
Who do you think should make the decision about whether or not the child comes forward?
Who do I think?
Yeah, either one of you.
I think the judge should make the decision, and I think the decision should be that the child comes to court. I mean, I'm a clinical psychologist. I know a lot of therapists say you can't have the child go to court. I mean, some people are saying I'm the opinion of the therapist.
I think the question whether the child should that the judge gives the opportunity for the child to come to court, and the child makes the decision whether to come to court. Okay.
Or the GAL.
I think the child rather than the GAL, and I don't know that we're getting into this in this report, but everyone else rated, because we had other people rate how stressful it was for the kids, like the foster parent. Everyone rated it as much more stressful than the kids were rating it. So, I mean, everyone thought it was more painful, more difficult, whatever, than the kids were. So, the problem with having, and I think that the judge should give the kids the opportunity, and the children should decide not to go, because some kids said, you know, I don't want to see my father, and he's going to be there. The problem is that if you leave, there are a lot of other people that will then decide whether the kid comes to court. I mean, what, in that the worker or the foster parent, I mean, that if a lot of kids are not coming to court because you've said it's up to the kid to come, then then you need to look and see, are the children really given the opportunity to do it, if that makes sense.
Well, we could task the guardian ad litem to say, you need to ask whether this child comes to court or not. And that's a specific task given to the guardian ad litem, and then you know that it's at least been, and then ask whether it had been done at the time of the hearing.
I'm a GAL most of the time, and I always ask my kids, regardless of age, unless they are infants, if they want to come or not, and what probably will be talked about. So I preface court to all of them, and then let them tell me if they want to come or not. Most do, but some are very adamant they don't, even really older ones.
Did we answer your question?
I think right now all kids have an opportunity to come. I mean, usually it's up to the guardian ad litem whether they come or not. I don't think it's a good idea to enter a blanket order that they have to come.
There are other states that have court rules that say that every child should come to court unless the child's attorney files a motion either in writing or in person, and the judge then has to find good cause. So there is a presumption that the child is present. However, the guardian ad litem or the child's attorney can say, well, my client didn't want to come, and the judge actually has to find a good cause and put it in the court order. And I think what that does is, you know, because it's in every court order, that it shows to people that the judges and the court want kids to come to court, and there really has to be this good cause finding. And I guess my question about this was, did you look at any hearings where, as the attorney in the back pointed out, that the child was present during part of it, and then the child left during another part of it, and they could have talked about the other issues?
There were only 2 or 3 cases that we had observed where a child was dismissed halfway through, so that's not enough for us to really, I mean, that's more like a case-by-case analysis as opposed to, we didn't have a large enough sample for that.
How often were there cases where the parents asked that the children be excused?
I did not see it where the parent specifically asked for the child to be excused. I don't remember observing a case like that. Have you had a case like that, Judge Henry?
It's usually the parent's attorney gets a little squeamish and asks the client, do you think it's appropriate to have your kid in the courtroom? But sometimes it doesn't.
I guess that kind of leads me to a question, and maybe it's outside of what you were able to observe, but in these cases where there may be sticky issues that weren't discussed, you believe with the kids there, it can also serve as a reality check for the parents, that maybe the parents, I mean, we often, in cases, will, for example, have dirty UAs, and you can have elaborate stories of how it can't possibly be true because of this, or this, that maybe the kids there, I think there were some anecdotal stories yesterday that we get these far-fetched stories, but then when the kids are actually there, there's kind of a reality check for parents also.
And that is possible. We definitely saw the parents' attorneys speaking less often when children were in the hearing. But that, it could be that is part of it, is that they're just not going to contest an allegation.
I know you analyzed the length of the hearings. Did you make any anecdotal notes about whether or not they were productive hearings versus kind of the rubber stamp hearings where there wasn't any issues that needed to be addressed in court, so that you can kind of analyze the distinctions? I mean, generally, court's pretty boring. I presume you guys would agree with me. Sometimes you went and you're like, man, that wasn't there as just seconds I thought court was going to be. And other times, maybe there's some interesting discussions, but was there any information about what was your typical short review that had no issues versus cases where there's problems?
I think the best way to identify whether it would be a typical short review would be whether there were lots of issues that were discussed. So obviously if it was something where a 2-minute hearing, which I've sat in on, where everybody agrees to everything in the court report and so it's signed and then the hearing is over with. In those cases, we wouldn't have these topics like the current situation, visitation, permanency, all of those things come up, so they would be discussed less. So that goes back to the possibility that, and I can't say definitively, but the possibility that children are more likely to come to those rubber stamp type hearings as opposed to the hearings where there are more issues.
It's not necessarily bad if we don't talk about those issues. If it's presented well in the court report, we all know it, and the kids have been discussed with it and stuff like that.
Right. Right. I think the issue is more that the caseworker is more likely to bring kids to those hearings than to hearings where things are more complicated.
Any analysis on fault versus no fault situations where we had juveniles dealing with issues where maybe the focus was more on treatment for the juvenile and their participation in hearings in this?
We did not do a specific analysis on that. I think there were only like 7 or 8 cases. I could go back and check for sure, but I think there were only 7 or 8 cases where the focus was more on the child's drug issues or whatever. So it would have been a smaller.
I think I'm gonna move us along because we don't have much time and we're almost
Sorry.
finished, and then we can finish the discussion. But I think we have more good quotes.
We do. This 14-year-old girl said it would be helpful if the judge knew about me more and I was able to go to team meetings. Then I would understand what was going on, the process and the details of my case. So children wanted to hear more about what was going on. To give you a summary of our findings, is attending court harmful for children? We had no evidence of harm. Is it beneficial for children to attend court? And we found that it was beneficial. Those benefits included more positive perceptions of judicial fairness, trustworthiness, a better understanding of the case, and more comfort with both the GAL and the caseworker. Is the age of the child related to potential harms or benefits? We found no relationship with harm for children based on age. Older children did know and understand more, but older children were also more likely to have been experienced, so they may have been in the system for longer or been in the system multiple times. And then again, those were children between 8 and 18, so we're not talking about the difference between 3 and 4-year-olds, for example. Is judicial behavior with the child in the courtroom related to potential harms or benefits? We found that both asking questions and providing encouragement have a positive impact on the child. And then what is the impact on the court process? And we found that the hearings tended to be shorter and then less substantive, so there was less information that was discussed during those hearings. And again, there are lots of reasons for that, and we unfortunately are not able to identify or parse out exactly what those are in this preliminary study. But I think it is something that can raise some discussion about what's occurring when children are in the courtroom. There were also several cases where children had discrepancies between what their parents or their guardians ad litem or their caseworker felt and what they felt. So in this situation, this little girl said, I would like to go to court because I want to know about my dad. The caseworker was insisting that the little girl did not want to know anything about her father and for that reason refused to bring her to the court hearing. We also had another situation where a little boy was placed with his mother, or with his grandmother because of his mother's drug abuse. He was 8 years old as well. And his grandmother said the little boy had no idea that his mom was using drugs and did not want the little boy to go to court because she didn't want him to hear about that was going to be harmful for his development. And he said, my mom is almost done with phase 5 in drug court and I am very proud of her. Yeah. So kids know a lot more than what we necessarily think that they do, and while we may intend to be protective by providing less information or by not confronting mom about her dirty UAs or whatever, those may actually be counterproductive for that child. So with that, are there any questions? Yes?
Why did you pick 8 as the year?
I'm going to turn that over to Vicky because I wasn't there for the design of the study.
It's more, and it's on the lower end of, we were asking questions and using scales, and when you get below 8, the reliability of children's ability to do that task of, make a rating of 5 on strongly agree, and so that's the reason.
I know there are some advocates who believe that children 0 to 18 should come to court and should come to court every time. I've had difficulty accepting that. I regularly have adolescents in my court. Sometimes we'll have them 10, 11, 12 if they've expressed an interest in coming to court. But I have real difficulty on the issue of 0 to 5 or 6. You know, I don't know that I see the benefit, and I think any plans for any kind of study as younger children in this regard?
Well, I mean, I think we would like to do it. It would have to be a little bit different study because we couldn't really get as much about the children's perceptions in a reliable way. I mean, we could easily do it coming in and going out kind of thing, but even that, I mean, little kids, you know, they don't know what nervous means. I mean, some of the questions, or fairness, I mean, these are concepts. One of the things we did find, even with the young, so if we extrapolate downward, clearly the benefits of having a voice and you know, viewing the judge as fair are lessened as you get younger. So if, you know, so what we found is there wasn't that difference in harm, but that older children had more benefits of viewing the judge as more fair and all of that. We did find in another analysis of the data that younger children were less concerned about whether they got to speak in court. Older kids wanted to have a voice. They were more concerned about kind of how nice, this isn't way how nice, the beneficence of the judge, how nice was the judge to them. So Judge Porter was here yesterday and she said she wants to see the kids. So there are benefits to bringing young children, maybe indirect to the child, and that if everyone sees the baby growing up, maybe people will work harder and faster and all that, and that might be an indirect benefit. Well, you might, but clearly we have not found anything to see that, we don't think that little tiny kids benefit personally directly from coming to court.
But as a defense lawyer, it does benefit your client if your client is very affectionate towards the child that comes into court and the child runs into the mother's arms and says, "Mommy, Mommy, I love you," all in front of the judge. And you know, that may completely turn the concept or the perceptions of what this parent is like as a parent.
Absolutely.
Now, it's also backfired as well, so.
Well, we have just a couple more minutes for questions, and I'll stand up here as well. And then I do want to invite you to the same room. Is that where we are meeting? Andrea is going to do another presentation on her wisdom from traveling the country and working with courts all around. It's the room over there on the role of the judge and children coming to court. So some of you may want to hear what she has to say. But any other questions?
Was there any data that you pulled out regarding like therapy? If anything affected that more? They were wanting to open up easier on the real issues because they were kind of hit in the face with, oh yeah, I had a positive UA and my child no knows.
We didn't ask
Nothing.
anything about
And I would just have to say, going back to your comment earlier, it's just kind of sitting with me, on whether the hearing was boring. It doesn't matter. To a young person, we know that every 6 months, at least, there's a hearing about our lives. And if we're not invited and we're not included, whether it's boring or not, whether you think it's boring or not, it matters to us. You're making decisions for the rest of our lives. And what's going to happen with the next 6 months. And 6 months to a lot of us who are, you know, older now and professional, and things go really fast. 6 months goes by like that. But to young people who are sitting in foster care or sitting in a placement that they might not like, or scared because their case is still reunification and they don't want to go home, you know, they need to be there and they need to know that these people do care about them and they are talking and things are happening. They also need to know who's making those decisions. I think the blame gets placed on different people if they're not actually participating in the court hearing. And so it might seem boring to people where it's your job, but it's these children's lives. It's our lives, and so it does matter whether it's boring or not. So.
And I wanted to say one other broad speculative thing, which is that there is children in the foster care system are at grave risk for getting into the juvenile delinquency system and the adult criminal system, present company accepted. But, and there have been studies that show that youth that have viewed the legal system as more fair procedural justice, they are less likely to act out. And so you've got kids who are growing, from when they're very little, and that's the kind of long-term, that are growing up in a system that they are at risk for getting in trouble later with the legal system. And there's a golden opportunity for you to have them feel the legal system is fair and trustworthy, and maybe minimize a little bit their own personal risks later, and public trust and confidence in the courts and whatever. I mean, judges, we've heard kids say, my judge rocks, I love my judge. There wasn't a child that said anything other than glowing. And when you're up there, you're the most important people in the room. That if you spend a minute or two, it will be timed. I mean, when kids really thought it was great, we timed how long judges talked to kids. It was often a minute and a half. I mean, we're not talking about huge things, and that makes a big difference. If someone is really paying attention to you, and that they've read your file and that they care. But anyway, Judge,
Well, no, we're getting into it. I was looking for specifics, because those of us that do not have a strictly juvenile calendar, we get to see both sides of this thing. We get to see the adults down the road, and our unsuccessful 3As become our 3Bs, and our 1s, 2s, 4s, whatever the case may be. So it's a lifelong deal, and every time we win,
Preliminary hearing.
we have got a life that's turned around. I tell the CASAs when we swear them in, you do not know how much good you potentially are going to do. Every kid that gets to change, you've eliminated another generation of malfeasance in terms of raising children, and it's just it's a no-lose deal as far as doing something for the kids.
Well, thank you very much.
Thank you.
Right, sometimes they just use them, yes.
Ready for this?
Then it's locked in a real way. We do that now, by and large, but it's mostly with the adolescents. And I think we've down to 8. I'll go down to 8. So I'm willing to do that. So, and I do think for the teenagers, there's absolutely a huge benefit. It's a huge benefit for the teenagers who really need to feel like they are part of that decision-making process, and that they need to have that voice.
And actually, it's great when research actually finds things that people tell you as well. But the younger kids, they didn't need to have their voice. But they wanted people to be nice to them. I mean, not that they wanted, they really were affected greatly on how nice the judge was. Whereas the older kids wanted the judge to be nice as well, but they wanted to actually speak.
Thanks.
Mother in prison for drugs and so forth. She writes more letters. Now it's kind of the first time you get up. Now there's some problems. Pull the trigger on this one, but this girl needs to know. Oh, the little brother and little sister.
They're not together.
Well, one sister is not the retarded. Brother smoker, sister. First, I don't know. Spreading the girl. She was really worried in Boston. Of course, everybody loved Boston. I'm sorry. These people, they get to that now, and I some kids, it's gotta be the most difficult job in this time. But we already hit this kid, but very good, not that one. But, God bless her, and she might be letters. And I'll submit it to parties, I will work with those, and genes. But one of the things with mine is the first discussions about kids under 12 should go to court, just like the people say. One of the biggest is that it's not going to be, what's not what you want. You see somebody like that, very traditional, and you not see this stuff all excited about something.
You know, today, I mean, it's a
This
conference,
one,
yeah,
just
this conference, it's,
these GAs and stuff, they're getting 3 days a week. They're coming here. And I mentioned, we were also doing some course in the region, and so guys in the notes of the out of these, those were some. They got no spots, and one of them, when somebody coming down, they would say, well, here's what happened, and we're ready some rules. And they come in and say, oh, this is what GAL means, this one.
see, I think, you know, I was gonna say, because it would be great to have a couple hours at a statewide county board, you know, on this. Although I think that the Supreme Court in Lancaster County, they're having a big fight in Lancaster County, something about fees, I don't know. But right now, they may not be against the, but no, I think,
At least put them in protection to protect the backside.
right.
And, you know, besides the job, I can also mention this within the community. They put them in a certain time, there's people.
And I think it would be, or certainly, you know, maybe twice a year. You ought to invite the community and the county board, but I think having a county commissioner on your group would be excellent.
Well, something, so at least they can look and say, well, non-volatile, you know, that's why I told the classes here, so the first steps were to picture, put it right through the file. So you know, the governor this morning, Christmas, so.
Well, would you